Hi, welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. We cover four big questions in this series, and today we are talking about the fourth, which is holding interest in property. The way married people hold property has been the subject of many contentious cases in family law courts. It's most relevant, of course, during a divorce, when unfortunately the disposition of property becomes an important part of the resolution. To understand how property rights are allocated upon a divorce, you have to know how property can be held by married people in the first place. That is the subject of this video. There are two types of property when it comes to married people: community property and separate property. 9 states say that property acquired during marriage, including income and including real property, is automatically community property. None of those states, by the way, recognize the ability of married people to create tenancies by the entirety, a topic covered in another video. Community property means sharing 50-50. It means that both spouses can possess the property. Unlike a tenancy in common or joint tenancy, no spouse acting alone can convey his or her undivided half share in community property except to the other spouse. A spouse cannot move for partition without the consent of the other spouse. Separate property, different from community property, it includes assets the spouse brings to the marriage, like inheritances, gifts, or even bequests during the marriage that are separate. Separate property can turn into community property if it is co-mingled. So if you put money you receive from an inheritance into a joint bank account, that property, which might have been considered separate, will now definitely be considered community property. Upon a divorce, community property is usually divided equally. Community property systems are not necessarily simple, but they do try to create fairly mechanical rules to someone so that people who are contemplating divorce can figure out with some accuracy what they might receive. In non-community property states, both marital property and separate property are recognized. However, courts will divide that property using equitable division based on a number of different factors, including the length of marriage, the income prospects of a spouse, the number of children. Courts may award maintenance, alimony, or spousal support. So marital property states use standards instead of strict bright line rules like the 50-50 rule in community property states. Some people say that you are likely to get fewer trials when you have a state that uses equitable division to divide property, because many litigants are risk averse, and because the fact that you can't predict the outcome means that settlement will be preferred over trials. So I encourage you to think about that. I also wanted to include a quick mention of the concept of homesteads. Usually the most valuable asset of a married couple is their home. So it's important to note that when one spouse dies, there is usually a statutory homestead exemption for the spouse to live in the home for her lifetime against the claims of creditors. Unfortunately, however, a court may order the sale of a house during a divorce, even if both parties object. So while the homestead exception applies upon the death of a spouse, homes may not necessarily be protected during a divorce action. The reason for this is that couples may not be able to afford to maintain two residences. So despite the protection given in the homestead exemption, it's not always a slam dunk that a divorcing couple will manage to keep a house. So I will leave it there. There's a lot of complicated strands of community, marital, separate property, and the way different states treat those. But I think that's a good overview for now. I'd love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list, and I will see you next time.